Many survivors of Indigenous day school say the multi-billion-dollar settlement with Ottawa is causing more pain. CBC News has learned one survivor is appealing the agreement to the Supreme Court. Olivia Stefanovic is covering this story as she does so many of our Indigenous reports this morning. Tell us about this, the day school survivors, Olivia, and why they are looking to the highest court in the land now.
Well, Heather, this case comes from a day school survivor named Jessie Waldron, who says she experienced difficulties applying for compensation, not only because it resurfaced trauma, but she says she couldn't reach anyone from the settlement agreement for help, not the claims administrator Deloitte or the law firm hired to represent survivors, Gowling. Now, there was a hotline set up for survivors through this settlement agreement where they could call to get assistance with filling out their claims. Waldron said she did that multiple times, but couldn't get through. So at one point, Waldron says she drove all the way from her home in Grand Prairie, Alberta, to her First Nation of Waterhen Lake in northern Saskatchewan, a 10-hour drive. She was supposed to meet with lawyers from Gowling who were visiting the community, but when she arrived, Heather, she says that the meeting was canceled. So out of frustration and desperation, Waldron says she applied for the least amount of compensation, $10,000. It was only afterwards, when she spoke to other survivors, did she realize that she could hire her own lawyer. So she did just that, and she was given legal advice that she could have applied for up to $150,000 based on the abuse that she suffered at day school. So they tried to resubmit her claim, but she was denied.
I have to say I felt traumatized again, victimized again. I humiliated. I just the feelings were not good at all. I was angry, frustrated, traumatized, victimized again and again.
Now, Heather, Waldron says that she's not the only survivor in this situation. There are many other survivors, she says, who applied for the least amount of compensation because they could not get assistance from anyone to fill out their claims. Waldron challenged the settlement in court. She went before the federal court and federal court of appeal. And in both those decisions, the justices showed sympathy for Waldron, but they essentially said that the rules of the settlement are the rules. So she could only submit her application once, and now she's turning to Canada's highest bench to see if they will hear her appeal.
Olivia, this multi-billion-dollar settlement was supposed to mean justice for the survivors. Clearly, it hasn't in all cases. So what is the government's response to this?
Well, we had the chance to catch up with Canada's former Justice Minister, David Lametti, who was Attorney General at the time that this settlement was approved by the federal court back in 2019. And Lametti says that at that time, the government had good intentions, that it wanted to settle with survivors instead of continuing litigation in court, and that it tried to create a process that would be as painless as possible. So survivors in this case, they didn't have to go through adversarial hearings and be cross-examined by federal lawyers like they did in the Indian residential school settlement, Heather. Instead, day school survivors, all they had to do was fill out a form. But that's when the problem started. And Lametti says there are lessons to be learned here.
Did we get it completely perfectly? No. Can we do better next time? I hope so, because that's certainly what we're going to have to keep doing. These kinds of settlements will continue, and we're just going to have to keep improving on the process each time.
Now, Heather, we reached out to Deloitte and Gowling for a response for this story. A communications firm got back to us denying our interview requests, but did say that they will not comment on third-party views about this court-approved deal.